Welcome to another episode on the Law Report. Today we are going to look at the defense of alibi. I know many defense lawyers may have come across clients who, when retaining them, would have asserted that they have an alibi. Turns out what they really had was a denial. What they were really saying is that they did not commit the offense for which they have been accused, but their defense did not rise to the threshold of an alibi. So let's discuss the alibi defense.
You have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to speak to an attorney and to have an attorney present during any questioning. If you cannot afford a lawyer, one will be provided for.
An alibi is a statement by a person under suspicion in a crime that they were at a different place when the offense was committed. So during a criminal trial, an accused can raise a defense of alibi if the defendant or the accused can prove that they were at a totally different place at the time when the offense was committed. And this is usually supported by evidence, maybe CCTV footage or a witness who could testify that the accused was indeed at a different location when the offense was committed. Maybe the accused was at work. One of his co-worker could attest to that. Maybe the timesheet could be used to show that he was at work at the time the offense was committed, or the security cameras, etc. Now, under the criminal procedure rules in the Turks and Caicos Islands, at section 46, it sets out that if an accused intends to rely on an alibi defense at trial, that the accused must give intention of this defense using Form 5 as set out in the schedule, and no later than 7 clear days of the first case management conference in the magistrate courts, and 7 clear days of the first plea and direction hearing in the Supreme Court. The accused must give particulars in writing to the Director of Public Prosecution, consistent with the requirements of Section 5 of the Evidence Special Procedure Ordinance. So let's look at what the Special Procedure Ordinance dictates. Section 5 of the Special Procedure Ordinance requires that notice of an alibi must be given to the prosecution or to the Director of Public Prosecutions. So Section 5(1) states that evidence in support of an alibi means evidence tending to show that by reason of the presence of the defendant at a particular place or in a particular area at a particular time, he was not or was unlikely to have been at the place where the offence is alleged to have been committed at the time of its alleged commission. A defendant, according to Section 5, subsection 2, a defendant and trial shall not, without leave of the court, adduce evidence in support of an alibi unless before the end of the 7 days beginning with the day after the day on which the plea and direction hearing ends, or such other period, he gives notice of particulars of the alibi. So what this subsection is saying is that if a defendant or his counsel do not file or give notice of the alibi within the requisite time set out by the section, then they would need a leave of the court in order to do so. And when the term leave of the court is used, it means permission of the court. So then the defendant or the defense would have to show why they weren't able to give notice of the alibi within the required time. Subsection 3 states that a defendant and child shall not, without leave of the court, call another person to give evidence unless A, the notice under subsection 2 includes the name and the address of the witness, or if the name or address is not known to the defendant at the time he gives the notice, any information in his possession which might be of material assistance in finding the witness. And B, if the name of the address is not included in the notice, the court is satisfied that the defendant, before giving the notice, took and thereafter continued to take all reasonable steps to secure that the name or address would be ascertained. C, if the name or the address is not included in the notice, but the defendant subsequently discovers the name or address or receives other information which might be of material assistance in finding the witness, he forthwith gives notice of the name, address, or other information. And D, if the defendant is notified by or on behalf of the prosecutor that the witness has not been traced by the name or at the address given, the defendant forthwith gives notice of such information which is then in his possession, or and subsequently receiving such information forthwith gives notice of it. So to break this down very simply is that a defendant is required to give details of any witness he intends to call as an alibi witness. This should be done in a timely manner according to the ordinance to afford the prosecution to carry out their due diligence. And why the prosecution would want to find the witness and probably interview the witness to see if the alibi actually holds up. So the defendant cannot ambush or surprise the prosecution by coming at the last minute and say, I have an alibi and I have an alibi witness. And at the time that you say that this offense was committed, I was not there, I was elsewhere. And I have witness to prove that. No, this must be done within reasonable time set out in the ordinance to give the prosecution enough time to check out the alibi. And why? Because the prosecution, once the alibi defense is raised, the prosecution has a burden to disprove this defense beyond a reasonable doubt. And how would they be able to do that if this defense is raised at the last minute and they had no notice? So, ladies and gentlemen, an alibi defense, in a synopsis, is where a defendant who is accused of committing a criminal offense asserts that at the time the offense was committed, that he was not present and therefore could not have committed the offense, that he was at another place and therefore it was impossible for him to have committed the offense that he is accused of committing. Secondly, if the defendant intends to raise that defense, they must give notice within the period set out by the ordinance. Thirdly, they must give the details of any witness they intend to call. And let's say that they may not intend to call a witness, but they may intend to show security footage or CCTV footage that they were in a completely different place. Then that too must be handed over to the prosecution so the prosecution can examine the footage in order for them to discharge their burden of disproving the alibi defense beyond a reasonable doubt. The fourth and most important thing to note in the alibi defense is that if notice is not given within the time specified in the ordinance, the defendant may be barred from raising the defense. And in order for the defendant to rely on that defense, if they didn't give the requisite notice, they would have to apply for permission from the court to raise the defense, and they would have to justify why the notice was not given within the time specified. I hope this episode has been of some assistance to you. If it was, please like, please share, please comment. Most of all, I thank you for taking the time out to look at this episode. Cheers.